Well, good morning, everybody. I want to express my gratitude toward Gun Owners Radio and San Diego County Gun Owners for having me here today. Rich specifically has done a tremendous job advancing our Second Amendment rights, so thank you for carrying the flag for us. I'm truly grateful for any opportunity that I have to help participate in this fight that we're all a part of. Just a little bit about myself so you know who I am. My name is Colin Rudolph. I'm a criminal defense attorney in San Diego, and I'm here to talk about the future of the Second Amendment and the Ninth Circuit. In my criminal practice, I generally focus on cases relating to DUIs, drugs, and guns. So I guess the ATF would not like me very much. I practice in state and federal court, and the federal court is the very same where St. Benita's is a judge. But before we dive in, I have my contact information up here. I have some cards in back if you want to check that out later. And it's enough about me. Let's talk about the law and some guns and how they affect you. So our critical topic at hand right now is the new Bruin standard. This is shaping the landscape of the Second Amendment rights in the Ninth Circuit and beyond. This is the part where people usually talk about the old Heller standard and try and explain how it's changed. But I'm looking past that because it doesn't matter anymore. This two-step test that Heller used to be, it doesn't matter to us anymore. We're going with Bruin. That's the only thing that should matter anymore, so I'm just going to stick on with that. When you heard the Bruin standard, it's the New York Rifle and Pistol State case that was a big monumental Supreme Court of the United States case that we won, and that changed concealed carry for everybody across the nation. And more importantly, it changed how the courts look at it. So the Bruin standard, it states, when the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct. The government must then justify its regulation by demonstrating that it's consistent with the nation's historical tradition of firearm regulation. Only then may a court conclude that the individual's conduct falls outside of the Second Amendment's unqualified command. So this serves as a guide for judges in determining the constitutionality of gun regulations. Essentially, it states that the Constitution protects an individual's conduct when it aligns with the Second Amendment, the text, history, and tradition. So the text, history, and tradition are the crucial components of this standard. The text refers to the original Second Amendment as it was written. And then we talk about the history and tradition. So history, it relates to the historical analogs at the time of creation and the tradition to existing prohibitions. Analogy plays a significant role as well. It involves comparing laws against different times. So when they're making the comparisons, as I have some examples right here, so Z law is more prohibitive than X law in 1823, or X law is like Y law from 1799 because they ban the same feature. So both sides are making arguments that sound kind of similar to that. So we look at the law that we're trying to challenge, and then we look at the laws that were back in the day between the formation of the Constitution and then also Reconstruction era. So it goes from about 1776 roughly up to about 1860s. So the government has to find some sort of historical analogs that will be similar to what they're trying to restrict today to justify their position, what they're doing. And of course, it's a lot easier for us now because we don't need to find those analogs. In fact, we're just trying to fight against the ones and say whatever examples they give us, why they're not significant enough, why they're not close enough, they're not related enough to the law that they're usually using. A lot of the times they're trying to use laws that are not close to what it is. They're just grasping at straws right now, the government. So we're just trying to combat that and try and explain that those don't make any sense. We don't have this history of doing this, so that the laws that they're trying to enforce now, they should not be constitutional. And what's really important to know about this standard is that it's going to influence every Second Amendment challenge. And it's already having a significant impact, and I'll talk a little bit about that in some of our cases that we have going on right now. So Andrew Branca is another Second Amendment attorney that I watch pretty often. I try and get a lot of information from him. He has a channel called The Law of Self-Defense. So he breaks down self-defense shootings and scenarios. And he said something in one of his videos that I had to write down, and I wrote a little quote here so that you could all follow it, because I truly believe the same thing. I consider myself a Second Amendment absolutist. Therefore, I believe the standard should be every gun control law on the books that is presumptively applied to law-abiding, mentally sound American citizens is unconstitutional. That's my standard, if I were a justice in the Supreme Court. However, we have the Bruin standard, but hopefully one day we'll get to this. So the impact on the Ninth Circuit and us. So what does this new standard mean for the Ninth Circuit? The shift toward Bruin standard has resulted in bunches of constitutional challenges being remanded. It's now incredibly challenging for the state to defend these anti-gun laws under this new standard, as I was describing before. A prime example is the Duncan case, where Judge Benitez declared the magazine ban unconstitutional under the Bruin standard. The state is going to appeal this, of course, and it's pending right now. Similarly, the Miller case is contesting the California assault weapons ban. Judge Benitez's original ruling was to strike it down, and then it did a little dance through the courts, it got held up, and then it came back to us for reevaluation. And Judge Benitez just last week made a positive ruling on that, which I'll get into in a little bit. And then don't forget, in the Ninth Circuit, we also have knives. They're covered under the Second Amendment as well, and there has been some significant cases that not a lot of people know about yet. One of them is called Teeter, and that challenged the ban on butterfly knives out of Hawaii, and that case won. That had gone through, gone through the whole appeals process already, and that we won that flat out. And they didn't even put a stay on that or anything. So that is in effect right now, that you can have a butterfly knife in California. Stays. So we talk about stays a lot in these Second Amendment cases. There's a lot of vocabulary that people have to learn to try and evaluate these cases. So I just wanted to bring this up so that we can all try and better understand how stays work. So it's a pause button for the enforcement of an order. So just like in the Miller case, they had a positive ruling for us, the injunction against the state, but the judge decided to stay the order. So he gave them 10 days to try and decide what they were going to do next. Generally, it's issued by judges that are a little afraid to rock the boat. They go in the side of status quo more often than not. However, there are standards that they are supposed to look at. So judges are supposed to look at these multiple factors when they're trying to determine if they're going to issue a stay. Whether the stay applicant has made a strong showing that he is likely to succeed on the merits. So if a judge looks at a case and they think that it's going to go a certain way and it's pretty obvious, they can use that to their advantage to invoke a stay. Whether the applicant will be irreparably injured by absent a stay. So this one's a little more important. This is the one that they end up using to justify their opinions more often than not. So this one, it would be if the state, their argument right now on their stay is that if we didn't grant them the stay and we didn't stop all the assault weapons from flowing in, then they were going to face irreparable harm, which we all know is a bogus argument, because if you look at the Duncan case, when we had Freedom Week, if those things were somehow dangerous, we would have seen all the repercussions right after that. We would have seen a spike in all the numbers, and we all know that did not happen. Even though we had millions and millions of mags flooding into this state, we basically sold out the whole country of magazines that week. So it was pretty interesting to see how that happened, and that there was absolutely zero spike after that. We all know that's because the size of your magazine has nothing to do with crime. Another factor is whether the issuance of a stay will substantially injure the other parties interested in the proceeding. So that one, it just depends on who's in the case and how they're going to be affected by it. So it's kind of like the last one, but you just look at the other parties that are in it as well. So for example, the rare triggers case and some other, the forced reset triggers, that's in another circuit right now. But for example, their company could just not keep going because they couldn't keep making what they were making if this ban was going to uphold. So what happened there was the judge decided to protect the parties that were in that case and issue a stay on that at the time. And then another factor, which is probably the least significant factor, is where the public interest lies, especially when it comes to Second Amendment, and we're talking about the Bruin standard. The public interest doesn't even factor in. That's not something that we're supposed to consider anymore, but they do consider it when they're talking about stays, generally. So now let's discuss some of the California recent laws like SB 2 and AB 28. These are examples of some laws that are directly affecting everybody in this room, and those are going to require some serious fights. So SB 2. This is a law that restricts where firearms can be lawfully carried with a CCW. Some of you may have heard of it in the past couple weeks. It's a CCW regulation. It requires more training to be eligible for a CCW. It upped the training from, it used to be 8 hours to get a CCW, now it's going to be 16. So they're doubling down on everything. It's going to take us 2 days to go in there and train and take off work and everything else. They're just trying to make it as cost prohibitive and burdensome on us as possible. It requires more steps to reapply for a CCW, and it's going to, I don't know why this is even a thing, but they make laws for things that we have in place all the time already. It's going to make the minimum age 21 years old. And it's going to limit the space where CCW holders can legally carry. That's a big problem for all of us. The 16-hour minimum training, that's a big issue. It's going to also include on storage and handling. There are also little sections in there about that. This law by itself is it's dozens of pages. So this is a very, very short summary of what it is. There's section 27. It would be PC 26230. That's the section that talks about the restrictions for where you can go. It restricts almost all places, most government offices, places of worship, parks, etc. That last one is a very big deal because it implicates almost everywhere a person would want to actually go. So if you look that up, you'll see one of the most important things on there is that you cannot go to any public place where it does not specifically say that you can come in there and carry. So if a store owner, like say you're going into even like Cold Stone or something to get a little ice cream with your family, you go in there and you have your gun on you. All of a sudden you've broken the law unless Cold Stone decides that they want to put a sign out in front that says that you can specifically conceal carry in there. But then again, no one's going to know in the first place. So we're just making all these ridiculous laws just to try and make it harder for law-abiding gun owners to do what they're supposed to do after jumping through all these other hoops, which is ridiculous because we all know that concealed carry holders are the most law-abiding people out there, even more than police. So AB 28. This one is one that a lot of people have heard about. This is the gun tax. So AB 28 imposes a gun tax of 11% on firearms, precursor parts, and ammunition. This is on top of existing taxes. So we already get taxed by the federal government on this. We have sales tax on this, and now they're going to add this on top. It's going to result in price increases for firearms because obviously, as everybody in this room knows, in basic economics, whenever there's a cost to somebody, it's going to get transferred down to the end consumer. So for this one, it's going to get all pushed down to us. So even though the tax is supposed to be against the FFL holders, and that's how it's supposed to go, is against the firearms retail sales, it's going to hit all of us anyway. So the other thing that I found that was very interesting about this is that the state, they cannot even afford this. So these laws are designated to make it more challenging for law-abiding citizens to exercise their rights. This tax in particular will affect everyone who buys guns, and especially will impact lower income individuals the most. Sadly, our compromises in legislation, they almost always lean against our rights, and it's essential to understand the implications of such laws. They often come from a lack of understanding with the real world impact when these people are passing these laws. And like I said, it's kind of crazy that we can't even afford this. In the bill, when I was reading it, a quote from the bill, it's kind of crazy that they would even ask this. The bill would require the Director of Finance to transfer as a loan $2.4 million from the general fund to the California Department of Tax and Fee Administration to implement these provisions as specified. So just implementing this, they're saying that it's going to cost $2.4 million, which I don't know what all the other taxes we've been paying have been doing, but that's what they're supposed to be for, with stuff like this, supposedly. So instead, it's really just going to be to hurt more law-abiding gun people. So here, we have some case updates coming up. I know a lot of people have been interested in all the Ninth Circuit cases, so I'm going to roll through a couple of them real quick so that everyone can see where we're at with these. So the Duncan case. The Duncan case, it challenges the magazine ban. It's an excellent example of how the Bruin standard is reshaping the landscape. Judge Benitez's order declared Section 32310 unconstitutional in its entirety. So that, of course, will lead to the pending appeal right now. This is a large capacity magazine law, of course, that is about 10 plus rounds. So if you have a magazine that has more than 10 rounds, it's illegal in California. Even if you got it during the Freedom Week, it's supposedly supposed to be illegal right now. Judge Benitez ruled this is unconstitutional in September, but the state did not like that. The state filed an emergency injunction. So the pause is going to be longer than Benitez's 10-day stay. So Benitez originally put a 10-day stay on this. However, when they put the emergency injunction in, the next courts took it up. And then because the next courts took it up, we have to wait even longer for them to make some real decisions on this. The state found a way to skip the 3-judge panel and move straight to the en banc. So the importance of that is, whenever cases go through the district courts and we try and fight these firearms cases, generally they start off in the district courts in the federal court. So it'll start with Judge Benitez or any of the other judges in the district, and then that's the district court. When they make their decision, it should go up to the appeals court in the Ninth Circuit. The appeals court in the Ninth Circuit, they're supposed to look at the case with a 3-judge panel. That 3-judge panel is that's the normalcy for what they're supposed to do with these cases. And then if they don't have a decision that they like, all the judges can get together and say we want to have an en banc hearing, and that has a good deal of different judges, usually somewhere between like 10 and 15 judges. It's not an exact amount, it's just whatever judges in the Ninth Circuit want to get on this case, they can get on this case. So since the Ninth Circuit leans so far anti-gun, all the anti-gun judges use this as an opportunity to jump on it. And for this case, they completely skipped that 3-judge panel and they went straight to the en banc, which they never ever do. It's something that they just skipped ahead, which is a good and a bad thing for us. It's a bad thing because they got their injunction right away and they're going to be able to stay this order longer than we thought. However, it's a good thing because that case is going to get fast-tracked to the U.S. Supreme Court if they decide to take it up. Because usually we have to wait for it to go through that process. This kind of sped up that process for us. So it's good and bad, and we'll see how this all plays out. The Miller case. So Roger Benitez made a decision on California's assault weapons ban. He's determined this to be unconstitutional. Benitez granted the injunction, which prohibits California law enforcement officers from enforcing several California penal codes that have to do with assault weapons. His decision reads, like the Bowie knife, which was commonly carried by citizens and soldiers in the 1800s, assault weapons, and he puts them in quotes in his decision, are dangerous but useful. But unlike the Bowie knife, the United States Supreme Court has said there is a long-standing tradition of widespread lawful gun ownership by private individuals in this country. However, now that was the end quote. However, Rob Bonta's office claims that this decision is misguided. They actually had a response up on their website within hours of this decision coming out, and it was a 79-page decision, so I doubt that they got through it or even read this thing before they put up their response to it. The DOJ lawyers are the ones who are misguided, I believe. Rob Bonta has decided to use your money to keep fighting this unjust law, and now he's submitted a notice of appeal. Judge Benitez has stayed this order for 10 days, which is not up yet, but we know that this is going to go to the next court. So this means that you can't buy your new AK just yet. Knives matter too. So additionally, let's not forget that knives matter in the context of the Second Amendment. Cases like Teeter have demonstrated the unconstitutional nature of some knife bans. So Teeter was a Hawaii case, also in the Ninth Circuit, that ruled on butterfly knives being unconstitutional. It found that history and tradition of regulating, but not outright banning knives. So that's very important because any knife ban is going to be a Second Amendment challenge, and we're going to have that roll through here in the Ninth Circuit as well. One that's going through right now, that is a new one that's very important to start watching if you care about it at all, is John Dillon's case. So John Dillon is another Second Amendment lawyer that you might know. He does a lot of work with San Diego County gun owners. He's actually the lawyer on the Miller assault weapons ban case. He gave a speech here yesterday for Gun Owners Radio, and he's a good friend of all of ours. He has knife rights cases, Knife Rights Inc. versus Garland. So this is contesting the constitutionality of switchblades. So this one is going to challenge how lawful switchblades are and if you can ban them or not. We all know that there is no history of banning switchblades. So this one is probably going to go positive for us. It just depends on how long this takes to get through the courts. I personally hope that someone goes after the prohibition of carrying fixed blades concealed. That's one of the things that I would like to challenge if I could go after these. There's so many different cases and so many different things to fight. But as far as our knife laws, I think that's the most egregious one. Is that I was talking about that earlier with some of the people in the audience here, is that the knife bans, a lot of people don't know, but there are conditions on what you can conceal and what you can open carry in California. There are no real restrictions on how long a knife can be that you can carry, but there are restrictions on the manner that you can carry them. So if you have a folder knife, you can conceal it, you can open carry it however you want. If you have a fixed blade knife, then you have to keep it open in a sheath and you have to have it out. And you can't have your coat over the sheath, otherwise that's concealed, and you can't have it just covered up in any way. So we all know that it's not really practical to do that kind of thing, especially if you're in a fight where you need to use your knife. Your attacker's probably so close that you probably only have one hand ready anyway, and I don't want to rely on my flipper in that scenario. I'd much rather have a fixed blade where I don't have to worry about that situation. However, maybe I'll opt for a switchblade when I'm allowed to have one of those, because that's a one-handed operation, and that'll be a positive thing when we can get through that. So in conclusion, Second Amendment, the future in the Ninth Circuit is going to be challenging. The Bruin Standard, with the focus on text, history, and tradition, is reshaping how we approach the Second Amendment challenges. It's essential to stay informed and to be prepared to defend our rights, especially in the new face of these crazy laws and these new regulations. So I thank you all for being here today. Let's continue our fight for Second Amendments, and remember to connect with me on the social medias. I have some links on here. I put out some videos that try and inform everybody about what's going on and keep you up to date on it. So do we have any questions? Yes, Russ.
Okay. The Supreme Court has ruled that federal agencies, non-elected people, non-legislative, can't make case law, can't make laws. They've done that.
Yes.
The trigger thing is being made out of whole cloth by the ATF.
Right.
Why can't we just immediately strike it based on that?
Because each individual rule that they interpret, those need to be challenged individually. I think that I would make a good case to just abolish the whole ATF, but that's just me, of course. I mean, they have gone way beyond what they've been instructed to do by Congress, and that's really what that challenge was about that you're talking about.
Yeah.
I know that there's just a million different things that they do that's overstepping, but those just need to be challenged by a case-by-case basis so that you can figure out, you know, who's making these challenges, how egregious they are, and where they're overstepping so that they can tell them where to back up.
It should be fairly easy with a Supreme Court decision against it.
It should be easy, absolutely. I mean, then you look at all the other entities and you see what they regulate, and it's hard to nail down, okay, this one, because they're also ever changing, as we know, with the pistol brace thing. So at first ATF said that it was okay, and then they changed their own definition of everything, and then they made everyone felons overnight by doing that.
My MAC 90, same thing.
Exactly.
Yeah. I got the letter from California DOJ.
Exactly.
That was a felony. So what I should do is take the trigger group and put it in a stream, because that's not a navigable waterway, and that should get me Sorry.
That might work.
I have two questions.
Sure.
On AB 2 and 28, that's being implemented by the majority in the legislature, correct? So, do we eventually, the public, the voters, get to vote for or against these two measures?
No, we don't get to, because it's done by the legislatures, and they are the ones who make the laws. So this is going through the normal process of them making laws, and Governor Newsom signed it. The only thing that we have to think about for that is they're not going to go into effect until July of next year. So we have a little bit of time for them to kind of marinate and figure out if they're actually going to push it forward, and then that also gives us time to make challenges, because we can't challenge a law until it's actually instituted. So we'll see in July of next year because they can always take it back if they want to. I don't think they're going to do that, but they can always bring it back. So that's why we're not allowed to challenge anything until it's actually instituted. So in July of next year, that's when we'll find out a lot more about this and where that's all going to go.
Okay, and my other question is on kinetic launchers, air guns. Do those fall under CCW laws?
Kinetic launchers, like air guns?
Air guns.
I don't know if those are actually classified as firearms. I know that they have their own kind of classification, but I don't know if I don't have enough information to answer your question right. Sorry, but if you reach out to me later, maybe I can look into that for you.
Okay, thank you.
Certainly. Anyone else?
Do you have any idea how the tax would be implemented?
How it would be implemented?
Yeah.
Government's gonna come take it. No,
I'm
my
is it going to be through the sales tax? Is it going to be?
Yes.
You know, how
My understanding from reading that law is that it's about retail sales. So when you're reporting your sales tax and everything else, it's just going to be an additional one that's going to be put on you at the end. It's going to be for all the retail sales, is what they say, because it's covering all the parts and everything else too. It's not just firearms. So you're going to have the burden of that, and then obviously you're going to have to charge your people more money, all your customers.
sales for everything they sell is going to
Pretty much. Yeah, it's California is a very anti-business state to begin with, and if you're a gun business, you're struggling for air. Yes.
Last question. Yeah, it's an ammunition question. I have firearms that are like during World War II.
Mm-hmm.
Why is it such a pain in the wazoo to get a box to show with the targets? And mostly both actually.
Well, there's some good guys upstairs who have some odds and ends calibers. You might want to talk with them. I know that it's tough when you have like some oddball calibers that aren't around anymore, but that surplus stuff, you know, you might be able to find that.
No new technology at all. Thank you very much.
Thank you.